court is now in session. Please be seated.
All right. Hope everybody had a good break, a good lunch. Madam Clerk, do we have any matters we need to address?
No, Your Honor.
Let's call the next case.
State of Tennessee versus Colby, Mason, Kilburn.
Your Honor, if you don't mind, I'll have a glass of water here. I'm fighting the head cold so I don't start coughing and interrupt my argument. It would help me.
You are welcome to have a glass of water.
Thank you very much. My name is Klein Preston of the National Bar. I represent Mr. Kilburn, and we're here on a appeal as of right from a conviction for first-degree murder.
Mr. Klein, is that your name?
Klein Preston, yes.
Mr. Preston.
Yes, Your Honor.
You weren't here earlier today, so you know that you have 20 minutes for your argument.
I'd like to reserve 5.
All right.
So this is an appeal from conviction for first-degree murder, and we have 2 substantial bases. Number one, we respectfully submit that the proof at trial was insufficient to support a finding of guilt for first-degree murder. On first blush, when you read the transcript, which I'm sure Your Honors have, the proof seems to be overwhelming. However, once you analyze the proof and the timing of the proof and essentially what the state presented at trial, we submit that the conclusion is that it's not overwhelming and that the state failed to prove first-degree murder. The state failed to prove intentionality or intentional killing and failed to prove premeditation. Now, why do I say that? Well, you had the primary testimony at trial. The factual testimony, non-scientific, was from Mr. Watts. Mr. Watts testified at trial differently than he did at the preliminary hearing. And I'm not here to argue weighing the evidence for his testimony. The jury accredited his testimony. However, when you look at the substantial amount of what his testimony amounted to, it's insufficient to establish first-degree murder for a couple reasons. Number one, Mr. Watts testified that the 3 gentlemen, after coming into my client's apartment, my client put a pistol, which he had shown to him, on a table, and they proceeded to go out onto the back patio where they were going to smoke some cigarettes and some marijuana. While they were out there, Mr. Watts, his testimony varied from the preliminary hearing to the trial. At one point, he testified that it was 10 to 15 minutes. At trial, he testified there from 30 minutes to an hour, which is a substantial distinction. He also stated, I believe it was in his preliminary hearing, that he had lit his cigarette and he had smoked it halfway down. At trial, he testified that he had leaned down to light a cigarette and had not even lit the cigarette when he saw an arm swing and he saw a flash and then a loud boom.
Well, let me stop you for a second. And I noticed this when I was reading this about the discrepancies about the time and you know what was, but he was consistent about the fact that your client shot the victim in the head with a pistol. And then the defendant told him to leave, and he winds up shooting the victim again. Is that correct?
No, Your Honor, I disagree. I think at trial he said he did not see the shot. What he saw was a swing. He heard the shot.
Right, and then he sees the person laying on the ground.
With the gun in Mr. Kilburn's hand. That is true, but...
And the person apparently, he saw it look like blood on the ground.
He did, and he's with a bullet wound into a cheek, I believe it was, at that time. But distinctly, though, when he says, here's a gentleman who testified, he's the key witness, and he states to the jury and the court that he didn't see essentially what happened. And so he saw the afterward, but he didn't see him pull the trigger. He didn't see it in my client's hand. And in fact, this is very important. the undisputed testimony at trial was that he did not see Mr. Kilburn go back and retrieve the gun. So we have some very big holes.
Well, the thing is, though, he obviously had a gun.
Well, we don't know that. And
Well,
the state
now,
didn't
Mr.
prove it.
Watts said he saw him with a gun,
He saw him with the gun after the shots.
which was within seconds, right?
We don't have a time on that.
Well, well, anyway, from what I remember from
It was,
the-
it wasn't long.
It
It
was very,
wasn't,
very, and then he tells him to leave, and he hears another gunshot.
that is correct.
Okay.
Moments later, which is not time, but yes, that part is true.
Okay, so explain to me then how the proof that was adduced at trial doesn't establish that this was an intentional act?
Well, because we don't, number one, based on Mr. Watt's testimony alone, we have this gun on a table in another part of the apartment. Then something happens, which is not explained. We have proof of what happened after the event. But we have a hole here in what exactly happened with that gun, who had the gun initially. Was there any kind of struggle? We don't have anything in the record
What
that
about the phone call the defendant had with his mother, and she asked him, was it self-defense, and he said no?
That's important, yes. And the interesting thing about that phone call is, if you listen closely, it's Exhibit 19 to the state's, in the file, in the proof, Exhibit 19. And I have it here on my phone if you'd like to.
No, I don't need to hear it.
I know, okay, I'm sure you've all listened to it. I don't mean to suggest otherwise. But if you'll listen to that tape, there's another conversation that my client is participating in at the same time. Now, I'm not asking you to reweigh how the jury interpreted that, but my client could very well have thought that he killed Mr. Stem. Why could he have believed that?
What?
Ma'am?
What did you just say? I'm sorry, just repeat what you said. I didn't grasp it.
Okay, he could very well have thought, I killed him and it wasn't a struggle. At what point of these instances? Because you have two events. You have the first shot, which surprisingly, we don't have any proof from the only witness who was able to testify at the trial who didn't see it. There was no proof as to that, which is very interesting. And then, it's undisputed.
Okay, so there were only 3 people there.
There were only 3 people there. My client had a constitutional right not to testify.
Absolutely, and the jury had a right to infer logically, if there were only 3 people there, one person is dead, the other was ordered to run away, was shot, and was he shot in the back or shot at? I don't remember where is Mr. Watts.
I believe the inference was that the shot that he heard was the second shot to Mr. Stem. There were 2 shots to
You've got a really difficult burden at this level.
I do, but when you look at
you arguing facts to us, and I tried to really listen to what your colloquy was with Judge Campbell. You keep arguing facts, and that's not what we do.
Well, I understand, but what we do is we look at what the proof was and was it sufficient. I'm not asking you to weigh the credibility of Mr. Watts. I just simply point out that Mr. Watts testified different ways, and what we don't have from the state are the answers as to what happened between the time he was.
Are you saying the jury couldn't logically infer from what they were presented that your client intended to shoot or knowingly shot, which was the verdict, that he knowingly killed the victim in this case?
That is absolutely the fact. But then you have 2 events here. So you say, okay, put that aside. Now we have a telephone call from with Mr. Kilburn between him and his mother at the jail. And he says, if you interpret it that way, for argument's sake, let's say, yeah, he said it wasn't self-defense, yes, I shot him. And the state didn't prove this, but the forensic pathologist testified that either one of the gunshot wounds to the head were fatal, or could have been fatal. We don't have a time of death other than at a later point. There's no proof in the record that says he was dead upon the first shot. So the state did not prove, but what they did prove was.
Why are these alternative arguments, or we can consider these alternative arguments that were rejected by the jury? I mean, you're savvy, I get it. You sound like you've been a trial lawyer for a while, or a lawyer for a while, so you know how to
It's the
dissect
hair,
it down.
it's the receding hair, isn't it?
But the jury really rejected all these things.
I understand, Your Honor, but there have to be facts, there have to be proof to support their verdict.
But here's the thing, the way the way this works is that all this, what you just said, was presented to the jury. The jury considered the proof, considered the people, considered the credibility of the witnesses, and made this factual determination. Now, we're kind of stuck with that, unless it is just there's absolutely no proof at all to support it. And that's why I'm asking you, I said, what proof is there that undermines this business about it being an intentional act or a premeditated act? Because right now I haven't heard anything.
Well, I would submit to you the record is totally void of any kind of facts that would prove intent or premeditation.
Well, now, your client surrenders to the jail
He does.
and says, I murdered somebody. And this is before they even knew it happened.
I agree.
They have to contact the police. We just got a report of a shooting. So he's over trying to surrender before the police have even been notified.
But from a legal basis, let's take the state's proof where they through the testimony of Dr. Deering, or forensic pathologist, who said either shot was fatal.
Okay.
If Mr. Stem was deceased upon the first shot, which very well could have been. We don't know. The state didn't prove when he died,
So
which shot killed him.
What is the relevance of that then?
Well, the relevance at that point would be that if Mr. Kilburn fired the second shot, assuming for this argument that he fired the second shot, then if he were already deceased, that's not first-degree murder.
Was that the defense at trial?
Well, that's what the proof is, and
I'm kind of confused. Are you implying that this was self-defense?
Well, it was argued that it was self-defense. That was argued at trial.
Based on the bullets?
Based on the proof at trial, Mr. Colby, who was the trial attorney, I was not the trial attorney, he argued that it was self-defense, and it's...
And what proof supported self-defense?
Well, he took the testimony of Mr. Watts and his statement that he saw an arm swing. He did not identify whose arm.
The unidentified arm.
The unidentified arm, and, then a shot rang after. Our position is, Your Honors, respectfully, that if he were deceased and the state did not, they put on proof to say that either shot was fatal. Well, then we choose shot number one, okay? We submit then that he was fatal based on the state's own proof. Then we would elect to have the first shot have been the fatal shot, which we submit the proof is insufficient, because here you have a witness who testifies about an arm swing. He doesn't, I know I'm getting into the evidence that the jury had, but my point is, and our position is, it was just insufficient to arrive at, proving intent, the intentional conduct and the premeditation. Particularly given the fact, based on Mr. Watts' own testimony, that the gun was the last he saw from Mr. Kilburn that was put on a table inside the apartment, and he did not see him return to get it. So, we have this void, even though we've got a so-called eyewitness who looks down apparently momentarily and sees nothing. It's almost like a Sergeant Schultz argument, I see nothing, and but that's the basis for the...
You got one.
I get it.
You got one, yeah. See, I'm aging myself again, So, respectfully, Your Honors, from a scientific basis, which if Your Honor say, okay, fine, the state proved he was dead on the first shot. Then the second shot, which my client, Mr. Kilburn, when he was telling his mother, yeah, I murdered a guy, he could have been shooting into a deceased person. That's not murder. And so if you take the state's proof and give them the every argument in favor of what the jury's verdict was, you still have a gaping hole in what happened. And with that them having to make essentially leaps of faith to arrive at a first-degree murder conviction, respectfully, that should not satisfy the requirements of intentionality or the premeditation. Unless you have any other questions, I'll.
No, thank you for your argument.
Thank you, Your Honors.
Mr. General Wilbur.
Good afternoon. May it please the court, Lacey Wilbur on behalf of the state. Your Honors, the defendant is not entitled to relief in this case. As Your Honors know, the standard of review is whether any rational trier of fact could have found that the defendant committed first-degree premeditated and intentional murder. And Your Honor, as you noted with the facts, we have the witness saying he saw the arm swing, flash, and then his ears rang. And I respectfully disagree with counsel. The witness did say, I saw, after that, I saw a lifeless body. I thought he was joking. I went to pick him up, and he was lifeless, was his word he used. And then he said he saw the defendant with the gun in his hand standing over the victim. The defendant looked at the witness and said, run. And as he ran, momentarily later, he heard a second gunshot. And either of those gunshots were fatal. He's arguing there's no evidence of premeditation and intention. I think Your Honors have grasped the subject, and again, any rational trier of fact could have found from just those facts alone. But we also have the defendant's own words, where twice he used the word murder. He told the corporal at the jail, he does this motion, and then he said, go ahead and restrain me, I did a murder. And then when the detective shows up, he said, I murdered somebody, I shot him in the head, and I disassembled my gun and out back. And that's exactly what the officers found when they went to the scene. So not only do we have the witness's statement, we have the defendant's own words and his mother's words when she asked him on the recorded phone call. And she's in the courtroom today, and I empathize with her completely. But she said, was it self-defense? Did he try to hurt you? And the defendant said no. And from all of this, any rational trier of fact could have found that the defendant committed first-degree premeditated murder when he shot the victim twice. Thank you, Your Honors.
Did you have rebuttal time?
Do I still have?
I think you still do, yes.
5 minutes.
I would just like to revisit a couple of things the General raised. We're not suggesting or stating that Mr. Kilburn had the gun at after the shot at that point. Our argument is that it wasn't proven that it was in his hands to begin with before the gentleman, Mr. Stem, was shot. There is no evidence in the record from which the jury should have arrived at any conclusion based on that gaping hole in the proof. And so, yes, he was standing over him afterwards, but there are a myriad of things that could have happened. What we don't have is what actually did happen. And that is, and our position is, that is the problem with the state's case, that they did not prove that that gun was in my client's hand to begin with. They didn't prove that it was in or wasn't in Mr. Stem's hand to begin with before the initial shot. And so after that, I would also bring Your Honor's attention to, when you listen to that tape, you'll hear a dual conversation going on between Mr. Kilburn and a female at the jail talking about different things. And at a certain point, I know that's getting into weighing the evidence again, but I would point out again that Mr. Kilburn's statement at that point, he could have been falsely believing that he killed Mr. Stem, because he shot him when he, allegedly shot him when he was lying on the ground, having been shot once in the head. But if he were already dead, his belief is not relevant to a conviction for murder. I mean, he could have been defacing a corpse, unfortunately. And so respectfully, I would submit that the proof at trial was insufficient to warrant this, the conviction that Mr. Kilburn received in first-degree murder.
Thank you for your argument, counsel. I'm sorry, did you have, okay. We'll take the case under advisement.
Thank you, Your Honors.
And I think that concludes our docket for today. Yes, Your Honor. All right, so we'll stand adjourned until the call of the docket tomorrow morning at 9:30.